Hello, my name is Brant Hunt. Today is the fifth day of March 2023. I'm going to be reading from this particular book here from Eustace Mullins, The Rape of Justice, Chapter 5. Um, we're going to plot through this book. We've probably gone through maybe about a third of the book so far. So this is like a 400-page book. So we're just going to continue to plot along here. Hopefully, in the near future, I'm going to be sharing from this particular book by, again, a book that authored is no longer living, which is a brilliant author, that is, Neil Postman, back in the 80s and 90s. Was a really sharp guy. And I'm hoping also to share this particular book, but also he did a book on disappearance of childhood. Uh, and all his books are really what I call standout books. Uh, to me, he was really ahead of the game in this whole attitude, whole idea, I should say. But anyway, let's get to the Rape of Justice by Eustace Mullins tonight. Okay, thank you for being here. I am actually on YouTube and Odyssey. Um, just simply type in "discerning what is true," and if you want to follow me, just put in the follow word on the my page and on your computer, I should say, and start following me, and it will come up and state what's going on, so you can continue to see the videos that I share. I would also encourage you to try to find some of these books that you can actually keep for what I would call the future for your children. Maybe it would be good reading for your young people who are in college, that they would hear these books on video, or actually, again, like I said, I would encourage you to get some of these books so that they would read these particular books. Okay. All right, let's get into the book, and thank you for being here. Chapter 5 is called The Supreme Court. And we're going to start with this particular book, this chapter, with a quotation from Thomas Jefferson. The germ of dissolution of our federal government is in the Constitution of the Federal Judicial. Yes, he's correct. Thomas Jefferson saw the fly in the ointment, so to speak. Whether a case may be made that the federal government is in dissolution, or whether it has at last achieved supreme power over the citizens of the United States, is a matter which has not been resolved. But Jefferson warns us, you see. The great object of my fear is the federal judicial. That body, like gravity, ever acted with noiseless foot and unalarming advances, gaining ground step by step and holding what it gains. Is engulfing insidiously the state governments into the laws of that which feeds them. Writing of Thomas Jefferson, Volume 10, page 189. I'm going to change something real quick for me to have an easier way to read. Hold on just a second. Whoops. It is so. Jefferson also stated, "It has long been my opinion, and I have never shrunk from its expression, although I do not choose to put it into a newspaper, nor like Priam in armor offer myself in as a champion, that the germ of dissolution of our federal government is in the Constitution of the federal judicially. Sorry, as irresponsible body that is for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing his noiseless step like a thief over the fields of our jurisdiction, until all shall be usurped from the states, and the government of all consolidated into one. To this I am opposed, because when all government, domestic and foreign, in little as in great things, shall be drawn to Washington as the center of all power, it will render powerless the checks provided on one government on another, and will become so benevolent and oppressive as the government from which we separate. It will be as in Europe, where every man must be either pike or grudgeons, hammer or anvil. Our functionaries and theirs are wares from their same workshop, made of the same materials as by the same hand. If the states look with apathy on this silent descent of their government into the gulf which is to swallow all, We have only to weep over the human character formed uncontrollably but by a rod of iron. And the blasphemers of man as incapable of self-government because he's true historians. Writings of volume 15, pages 331. He's correct, folks. If you cannot self-govern yourself, that's why we're in such a mess, folks. Okay? That's why we're in a mess. If you cannot govern yourself and you want laws and you want to do those laws against your so-called enemy, you actually are putting a rope around your own neck also. Because one way goes the other way, you see. Jefferson continued in volume 15, page 341. Our government is now taking so steadily a course as to show by what road it will pass to destruction, to wit, by consolidation first and then corruption, its necessary consequences. The engine of consolidation will be the federal judicially, the two other branches, the corrupted instruments, you see. He went on to say, we already see the power installed for life. And that's correct. The foundation is already deeply laid for the annihilation of constitutional state rights and the removal of every check, every counterpose to the engulfing power of which themselves are to make a sovereign part. If ever this vast country is brought under a single government, it will be one of the most extensive corruptions, indifference, and incapable of a wholesome care over so wide a spread of surface. This will not be borne, and you will have to choose between the Reformation or revolution. If I know the spirit of this country, the one of the other is inedible. See, he's already preaching this, folks, and he's basically seeing this in the early 1800s already. Before the canker has become inveterated, before its venom has reached so much of the body politically as to get beyond control, remedies should be applied. Jefferson was not alone among the founding fathers to warn us of the dangers represented by unbridled judicial system. Now the Supreme Court has come to represent everything which they warned us against: excessive power, the destruction of the system of government checks and balances, and the annihilation of the principles of separation of powers. This development has come about because of the systematic amending of the Constitution, which was to guard the citizens from excesses of government power and its consequently abuses. To accomplish such amending, it was necessary to enlarge the states in a civil war, or more properly, a constitutional revolution. Before this goal could be achieved, the subsequently 13th, 14th, and 15th Amendments effectively repealed the Constitution guarantees which had been so painstakingly drawn up by the Founding Fathers. In place of the original intent of the Constitution, we were now saddled with the ruthless enforcement of the law merchant. The law merchant respects no individual rights, does not afford trial by jury, and renders useless the appellate process. The law merchant has converted the appellate courts, including the Supreme Court itself, into a rubber stamps for the admirably procedures and decision of the inferior courts. He's talking again about what we talked about last night, to do it with the law of the sea, and also with lawyers who are attorneys who work for the bar and are somewhat of a secret group also, who basically protect themselves. It's just like the Masons, Same thing promised also with what took place even with Skull and Bones at Yale University. The legal profession has carefully concealed from the American people the fact that we no longer have an appellate court system because the treadmill procedure of appeals continues to provide billions of dollars in fees. The legal profession continues to hold out the carrot on a stick. We have excellent grounds for appeal. The court has committed reversible error in numerous aspects of this case. And of course, the court has committed reversible error, and every error will be upheld by the rubber stamp appellate court. Although American court procedure remains a game of Russian roulette for the litigant, the attorney knows exactly how much chance the appeal will have. If the client has enough money for appeal, he will have appeal. You see, Abraham Lincoln also expressed his concern about the judicial, that is in March 4, 1861. If the policies of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. The Bill of Rights was affixed to the Constitution to assure the American people that their newly won freedoms, the result of a successful revolution, would not be abrogated by a latter tyrannical government. For more than a century, the Supreme Court had been actively denying those rights. The present era of judicial activism began with Oliver Wendell Holmes, inaugurated the era of positivism on the Supreme Court. By the way, when I was in college and taking classes, and I remember this name quite obviously, as though this guy was the greatest thing since sliced cake. And I believed it, not knowing what he was involved in. Holmes abrogated the rule of written law by his personal view that the judge does not merely read and interpret the law, he also writes the law. You see, he has judicial presence to actually to change that, which is not what it's about. In other words, what Oliver Wendell Holmes is doing is saying the Constitution wasn't good enough, so I'm going to change it. Okay, all right, and that's part of what I would call the amending process. You see, but what's happens if the judicial government, judicial power, that is the court system, comes along and it actually decides what's laws are constitutional or not. It's very scary in some ways, and then rewrites it. Holmes argues that law is not based upon fundamental or universal truths, a denial of the definition of law as a fixed power, but rather on the more psychological, that is, the felt necessities of the times. Do you see what's going on here? It's no longer based upon a foundation. It's now depending on what way the wind blows. Put this like this, and then check and see. This is what I call politicians. They check to see which wind is blowing, and then they decide how they're going to vote. Well, this is the same thing. Same thing. This doctrine claimed that the judge is the law. Meanwhile, Roscoe Pound was teaching his doctrine of sociological jurisprudence at the Harvard Law School, which demanded a pragmatic sociological legal science. In effect, this was merely a restatement of Karl Marx's theory of dialectic materialism. What was imposed upon the Russian people by armed force was to be fixed upon the American people by judicial fiat. When Franklin Delano Roosevelt appointed Felix Frankfurter to the Supreme Court, Frankfurter initially gleefully aside to Justice William O. Douglas was, if we can keep Chief Justice Hughes on our side, there's no amount of rewriting of the Constitution that we cannot do. This was the same Felix Frankfurter, a Vietnamese immigrant and socialist revolutionary who was labeled, so to speak, by President Theodore Roosevelt as the most dangerous man in America. Frankfurter saw his opportunity to use the Supreme Court as the vehicle to impose a socialist tyranny upon all American citizens. This is history, folks. You've got to go back and look at this type of thing to understand where it all started. This is my premise of the whole thing, and simply why I share this. Because the problem is simply people, you've got to see where it all went wrong. And most people are saying, well, it's wrong, but they don't know why. You see, they don't know why unless you read this information and look into it. And actually, Eustace Mullins did all the work for you. You see, and I doubt we could ever find another man as great as he is. But not only that, who was be able to go into the quote unquote the certain special library of the government, that is the Congress Library, to do that, because they won't do that anymore. They're not going to allow you to do that. The Wall Street Journal has opened its editorial page to views critical of the Frankfurter legal system. On February 7, 1989, professor of law, that is Stephen L. Carter, warned that the decisions of the court are the law of the land in the sense that the parties to them are legally obliged to obey them. They are not, however, the fundamental law of the land, not at least in the sense that the Constitution itself is fundamental. In fact, the decisions of the post-Frankfurter court are binding upon the parties only through the law merchant and not because of a constitutional orientation. Carter concludes his argument with the abolition that obedience to the courts is obviously among the most fundamental of our traditions. But surely obedience to the Constitution is even more so, you see. This flies in the face of Holmes and Frankfurter brand of judicial activism and the imposition of admirably procedures that is upon the American people. Its motto is the Supreme Court decisions are the law of the land, even though these decisions regularly reverse themselves to achieve the conditions of national instability, which the sabotagers have planned. Legal critic Walt Mann, M-A-N-N, tells us that the seal of the Supreme Court is not the standard judicial seal of the blindfolded maiden and the scales of the justice. Instead, it is a copy of the seal of office of the president. Notes appearing in U.S. Code 28 U.S.C. 44 and 28 U.S.C. 88, Appendix 1, indicate that the present Supreme Court is not the true Supreme Court, but an imposter. The original Supreme Court still exists in the District of Columbia, but its name was changed during Roosevelt's presidency in order to have a court which would support his National Recovery Act, legislation which was copied directly from the corporate state of Mussolini by General Swope, S-W-O-P-E, the president of General Electric and longtime vassal of Bernard Baruch. The original Supreme Court is defined in the Constitution, Article 3, and the 1789 U.S. Statutes of Law, the Judicial Act. That is, since Roosevelt seceded it, U.S. courts have lacked all first instant trial prosecutions and trial jurisdictions. Thus, the U.S. Criminal Court does not contain specifications of crimes, but specifications of overt acts. That is, criminal contempts of violation of previous injunction orders. The courts rely on the injunction process based on the violation of a court order, rather than providing a legal trial under the Constitution principles where evidence is argued and admitted or denied, with a jury making the final decision. Under this injunctional process, only the overt act violation of the injunction itself need be proven to attain a conviction. The information which has taken the place of indictments for violation of law has only to claim that a violation of the injunction has taken place. The crime itself will never be prosecuted. Do you see? Do you see what's going on here? That's why people go to the courtroom and says, where is the Constitution? And that's why they said, you can throw that out. Even the court, the judges say this, throw that Constitution out of here. The U.S. Criminal Code itself was originally a civil code, because the Criminal Code, Title 18, was included in the Civil Judicial Code and the Aliens and Foreigners Control Code, Title 8. The 14th Amendment was then written in order to provide the government authority to treat American citizens as aliens and foreigners, as decided by Frost versus RC 271 U.S. 583 596-7, which defined us as mere aliens, and Lehigh Railroad versus Russia 21F.2D 396, which ruled that the law enforcement powers in America apply only to foreigners, foreign relations, and international affairs. The doctrine of federal judicial supremacy was fastened onto the necks of the American people as irrevocable yoke, because it was done insidiously and under the cover of more striking and dramatic events such as the Civil War. After the Second World War, the judicial activists, who had thoroughly cowed the leaders of our two political parties, imposed a series of stunning decisions which in effect placed the American people on notice that they now had no rights remaining to them. They are the snake in the grass, folks. You've got a lot of issues with the president. You've got a lot of pressure issue with both houses, the Congress. But by God, the justice system is a joke. The situation, not only a joke, it's tyranny. It doesn't allow anybody to have justice. This decision was dramatized by Governor Orval Faubus, F-A-U-B-U-S, of Arkansas in a speech to the Arkansas legislature in August 26, 1958, in which he quoted extensively from the resolution passed by the Conference of Chief Justice of the state Supreme Courts early that month, concluding with their findings that the Supreme Court had been usurping the rights reserved to the states by the Constitution. It is not merely the final arbiter of the law. It is the maker of policy in many major social and economic fields. The activist pretension to judicial supremacy dates from the historical case of Marlborough versus Madison. It's all there. We've studied that. I remember that case, 1803. The decision was the work of Chief Justice John Marshall, who was the first to unwind what was in the Constitution and to gradually, just piece by piece, change things. He was the first to do that. Who had been appointed to the court by President John Adams, the leader of the New England School of Separatists. Marshall ruled that the has the power to strike down any law or act of Congress which violates the Constitution under Article 3, Section 2, Part 1, or the Supreme Law of the Land Clause, that is, Article 6, Section 2. However, Marlborough versus Madison, rather than being a sweeping review which established the court as the final arbiter of government power, was actually a partisan political squabble over the spoils of election victory. Congress had passed a new circuit court bill, that is February 13, 1801, which authorized 16 additional federal judges. President Adams at once filled them with Federalists, who were confirmed by the Senate March 2nd and their appointments signed by President Adams and sealed by the Secretary of State John Madison on March 3rd. Marlborough versus Madison arose from a comparable situation, the passing on February 27, 1801, of the District of Columbia Organic Act, provided for the appointment by the President of Justice of the Peace for Washington and Alexandria within the district. On March 2nd, the President nominated 23 justices for Washington and 19 for Alexandria, and sealed by the Secretary before midnight on March 3rd, the famous Midnight Justice of the Peace. The commissioners were delivered that same night by Marshall's brother James. However, William Marlborough of Washington did not have his commission delivered, which became the subject of litigation in December of 1801. The case was finally heard by Supreme Court in February of 1803. John Marshall believed that the commissioners were valid when the seal of the United States was affixed, rather than when they were delivered. Today, the Supreme Court has no file in the case of any of the papers relevant to it. The only record is that made by a reporter, William Cranch, C-R-A-N-C-H, that is. The court ruled that Marlborough had a right to the commission because of the power of the court to adjudicate the validity of an act of Congress. However, the court refused to issue a writ of mandamus, thus deciding in favor of Madison. This is based upon 1 Cranch at page 70. The court stated that the Constitution forbade the grant of power to issue the writ, but that the court did have the power of judicial review. The court ruled that the Constitution was the superior and paramount law, unchangeable by ordinary means, and the supreme law of the land. Section 13 of the Judicial Act of 1789 attempted to give the Supreme Court power to issue a writ of mandamus in an original proceeding against an officer of the United States, including the Secretary of State. The court concluded that Article 3 of the Constitution prohibited the grant of such power by Congress to the Supreme Court. Thus, the original dilemma that Secretary of State James Madison had worked far into the night signing commissions of justice of the peace for the Federalist Party, including Marlborough's commission, had part of his work undone when the incoming Secretary of State Thomas Jefferson, seeing the stack of signed commissions on the following morning, decided that he would not allow them and threw them into the wastebag. Marlborough then sued to obtain the commission he had been promised for his dedicated party service. You see this dirtiness here? In deciding the case, Chief Justice Marshall, one of the leaders of the Federalist Party, cleverly avoided the main issue before the court, that of partisan politics, and shift the issue to one of government powers by deciding that the final arbiter would henceforth be the Supreme Court. Thomas Jefferson delivered his opinion on the Marbury-Madison decision, stating nothing in the Constitution has given them, that is the Supreme Court, a right to decide for the executive, more than for the executive to decide for them. The opinion would make the judicially a despotic branch. Jefferson further warned about judicial supremacy in 1819, stating the Constitution on this hypothesis is a mere thing of wax in the hands of a judicial, which they may twist and shape in any form they please. However, the court was careful not to flaunt its newly assumed powers. Between 1803 and 1870, the court declared as unconstitutional only 6 acts of Congress, 3 of those being decided in 1870. From 1871 to 1899, it overruled Congress 16 times, a power which was increasingly used from 1900 to 1936 during the period of Holmes' judicial activism. During that period, the court rendered 51 decisions against the Congress. The battle over American Central Bank also sprawled landmark decisions by the Supreme Court. After the European Rothschilds had commissioned Alexander Hamilton to set up a central bank in the United States, immediately after the American Revolution, Thomas Jefferson led the fight against its adoption. In McCulloch versus Madison, that is 1819, the Supreme Court upheld the bank against the states. In Craig versus Missouri in 1830, the Supreme Court invoked the constitutional ban on state-issued currency to invalidate loan certifications issued by a state, a decision which severely affected the growth of state banks and encouraged the demand for a central bank. See how dirty this is, folks? See it? A longtime crusader against the central bank, that is Roger Taney, T-A-N-E-Y, was rewarded for his opposition by President Andrew Jackson, who appointed him to the Supreme Court in 1836. In 1837, the Taney Court reversed Craig versus Missouri, the decision of Briscoe versus Bank of Kentucky, and upheld the state law authorizing the issuing of banknotes by a state institution. Lawrence Tribe comments on this decision. The demise of the central banking system and consequently the eruption of the national finances played a large part in triggering the devastating economic depression of 1837. Although Tribe is a well-known legal scholar, he seems less aware of the fact about monetary history. Henry Clews, C-L-E-W-S, states in his book, 28 Years in Wall Street, page 157. The Panic of 1837 was aggravated by the Bank of England when it in one day threw out all the paper connected with the United States. As the present writer pointed out in Secrets of the Federal Reserve, the orders to refuse any American securities, shares, or loans came directly from Nathan Mayer Rothschilds, who thereby deliberately precipitated the Panic of 1837. The goal was to punish the United States for refusing Rothschild's central bank and to drive down the prices of all shares in the financial panic. Such shares then being available for purchase by the Rothschilds at a much lower price. That's what it's all about, folks. You see, it's always to benefit them. Does Tribe know anything of these details? A Harvard law professor since the age of 27, he is described by the Time magazine as one of the most powerful lawyers in the United States. He has long been in the $500 an hour fee range for consultation and may be relied upon to present a acceptable justification for establishment programs. With the advent of Zionist power on the Supreme Court in 1916, the head of the World Zionist Organization, that is Louis Brandeis, being appointed to the court by President Woodrow Wilson, the court moved from its delegation to the enthronement of judicial supremacy to a new program, the supremacy of Zionist interests around the globe. Because the Supreme Court decisions are not binding upon other nations, this program first succeeded in placing Zionist interests firmly in control of the federal offices in Washington, where they were then exported to the rest of the world as American interests. President Wilson appointed Louis D. Brandeis to the Supreme Court June 1st, 1916. He served on the court 22 years. Another Zionist, Benjamin Cardoso, was appointed February 1st, 1917, serving 23 years until 1939. The Jewish seat was then given to Felix Frankfurter by Roosevelt in 1939. Arthur Goldberg served in the court for 3 years. That is, A. Fortas was appointed October 4th, 1968, later resigning after charges of involvement with wealthy Zionists who had matters before the court. The Brandeis appointment to the Supreme Court has been explained as a result of $50,000 contribution by Bernard Baruch to Wilson's re-election campaign. Wow. You think that's you think that's what they're doing now? Look back 100 years and see how, quote unquote, Woodrow Wilson pays back those that give him money to run for election. You see this? And also a blackmailing effort by the Zionist leader who held Wilson hostage for the Peck letters, a number of which purportedly established a secret liaison between Wilson and a Paramount. Yes, I remember that. Now, what I remember simply is what I've been taught. And that was to do with that he was seeing another woman. He was not actually seeing, was seeing another woman, and he had some debts, which I think they handled that. But I think he was seeing a mistress, not his wife. And he wanted that. They knew that. And that's how they blackmail people, you see. Brandeis' appointment was affected by both elements, and indefeasible social activist. He had aroused strong opposition for years because of his controversial work, yet he was finally confirmed by the Senate. He was known worldwide for his fanatic leadership of the Zionist Organization of America. He fulfilled a continuous round of Zionist meetings and policy sessions, stating for the record that the Zionist affairs are the only important things now. That's a quote, folks. A curious allegation for a justice of the Supreme Court who was supposedly to be impartial, you see. Wilson later appointed Brandeis' mentor, that is Bernard Baruch, as head of the War Industry Board during World War I, and Baruch's partner, Eugene Meyer, head of the War Financial Administration, in charge of Liberty Loans. Baruch later boasted to Congress that as an economic czar of the United States, he daily exercised more power than any other man in the nation. It was Baruch who, with Brandeis and Wilson at the Versailles Peace Conference, wrote the impossibility of punitive reparation assessments against Germany, which made a second world war inevitable. A pivotal figure on the Supreme Court during the 1940s and 1950s was Justice Hugo Black. Max Lerner biography of Black's notes that he joined the Masons before he reached the age of 21. At the next step in his political career, he then joined the Ku Klux Klan, even though the Klan charter especially forbade the admitting of Jews, Masons, or Catholics. Black ran for the Senate with active Klan support and won. Black then supported Roosevelt's court packing plan in the Senate and was himself appointed to the court as a reward. Holy shit. After he was sworn in, the story was leaked in Washington that Black had been an active Ku Klux member since 1927. Despite a firestorm of protest from the liberals and communists who made up Roosevelt's entourage, Black refused to resign from the court, and Roosevelt refused to request his resignation. See, you basically can't even fire these people. You can't get them out of office, you see. A deal was made, and Black became known as one of the most liberal members of the court. He worked actively to offset the votes of the four horsemen of the Hughes Court, the dedicated conservatives, Pierce Butler, Willis Von Devontae, George Sutherland, and James McReynolds. As the traditional activist leaders of the court, Black led the writings of decision against prayer in school in 1954 as an abolitionist doctrine. In 1962, prayer case that is Black claimed that by way of the 14th Amendment, the Bill of Rights restrained upon the states were incorporated into the Constitution. This became the basis for a liberal wing of the court in future arguments, although other Supreme Court decisions refuted Black's claim. Justice Frankfurter ruled in Adams versus Cal, that is in 1947, that the notion that the 14th Amendment was a covert way of imposing upon the states all the rules which it seemed important to the 18th century statesmen to write into the federal amendments was rejected by judges who were themselves witnesses to the process by which the 14th Amendment became part of the Constitution. In Engel, etc. versus Vidal, Stephen Engel and other parents of the New Hyde Park, New York versus Union Free District Number 8, plaintiffs objected to a non-denominational prayer from the State Board of Regents containing 22 words drawn from the state constitution. It is, Almighty God, we acknowledge our dependence upon Thee. We beg Thy blessings upon us, our parents, and our teachers, and our country. This indigenous prayer had been repeated at the beginning of each school day with the Pledge of Allegiance. There was no compulsiveness of students to join in its recital. The Supreme Court itself opened each day sessions with the prayer. God save the United States and this honorable court. Prayer was also used as the openings of both House and Congress. However, Justice Black claimed that the school prayer served to set up a state religion and thereby violated the established clause of the Constitution. Congress shall make no laws respecting the establishment of religion or prohibiting the free exercise thereof. Black's argument that this clause forbade all religious expression actually perverted it into a prohibition against the free exercise of religion. The prayer issue continued to come repeatedly before the Supreme Court. In 1984, the court famous reindeer rule, that is, held at nativity scenes and memorials could be permitted on public property only if they were accompanied by secular symbols such as a reindeer, Santa Claus, or his elves. This decision has been condemned as a tortuous reasoning. It is not reasoning at all, but rather it is a conscious attempt to inhibit and finally destroy the exercise of religion in the United States. A succession of socialist activists' decisions by the court changed the quality of life for all Americans. The Shelby versus Kramer decision, that is 433 USI 1984/1948, outlawed restricted real estate contracts and changed the capital city of the United States from a white middle-class residential area to a largely black crime-ridden city, which is now known as the crime capital of the world. Its mayor, that is Mayor Barry, is continually criticized for his close associates with known drug peddlers, some of whom have now been arrested. Barry formerly ran a black organization called Pride, which collected payments from Jewish merchants on 7th Street in Washington for assurance that their stores would not be vandalized or set on fire. After millions of dollars had vanished into Pride's coffers, Mary Barry and his wife take the rap for the sum of $675,000, which had mysteriously vanished. An invading army had twice destroyed our nation's capital city, as the British did during the War of 1812, when it met with an armed resistance. However, when the Supreme Court decisions launched a wave of white flight and handed the city over to blacks, not a protest was heard. Shelby versus Kramer did not, as was widely but erroneously believed, outlaw racial covenants in real estate contracts. It did take on the language which was wisely used in such contracts, such as that quoted in Ringo versus Denhart, that the house on said lot now erected shall be used only as a dwelling house, and the same shall not be given, sold, rented, or subleased to a Negro or a person of African or Mongolian descent. Many such racial covenants also excluded Jews or other groups in an effort to continue the ethical makeup of particular neighborhoods. The value of the real estate depends in large part upon such restrictions. Once these restrictions were abandoned, the value of the real estate would plunge. Instead of outlawing such contracts, the Supreme Court did not face the issue squarely. To have done so would have violated the constitutional provision against the impairment of contracts. The justices of the Supreme Court carried out a flanking attack on their objective. While they were cowardly, would not allow them to outlaw such contracts. They ruled that the courts would no longer enforce such contracts by legal upholding them. Their rule of law weaseled out of the necessity stance by establishing that the provisions of such a contract could not be enforced by the courts. The famous interview with Philip Eltman in the Harvard Law Review, volume 1987, pages 817, revealed that the Department of Justice had intervened actively to secure the decision in Shelby versus Kramer, filing a 150-page animus curiae brief for the plaintiff, which was later published as a book. Eltman states, I have finished working in the NAACP, the ACLU, the American Jewish Congress, the American Jewish Committee, and other organizations. Eltman, as Felix Frankfurter's law clerk for life and close confidant was working for the plaintiffs as an amicus curiae, while his employer, Frankfurter, was hearing the case in preparation for handing down an impartial opinion. Eltman states that the Solicitor General of the United States, Philip Perlman, had requested that he prepare the amicus curiae brief, again, an improper procedure, because the clerk of the justice cannot intervene on behalf of either the plaintiff or the defense. The brief finally appeared with the names of 5 Jewish lawyers as its authors. Perlman was disturbed by this and demanded of Eltman, "Can't you find any Gentiles to work on this thing?" Thus, we find that the same organization which orchestrated the complaint of Brown versus Board of Education also masterminded the Shelley versus Kramer decision, which destroyed our nation's capital. Their presence was illegal, conspiratorial, and constitutional objective of justice. The present writer was living in a present home on Capitol Hill when the Supreme Court decision was announced. Within months, real estate spectators had begun the practice of bringing in one black family per block, famous practice of block busting. As the site of the black invasion, white owners would immediately sell their homes for as little as 1/10 of the amount they had invested in them. Fortunes were made overnight as Washington became a black city. That is, one Supreme Court decision changed a sleepy southern white city with minority black population to one of the largest black cities in the world. A crime-ridden, poverty-stricken enclave surrounded by well-to-do white suburbs in Maryland and Virginia. So that's how they did it. I don't have anything against black people, folks. That's not the point here. But the point simply was to destroy. That's what it was about. Newspapers carry headlines such as "Fear becomes billion-dollar industry" as sales of locks, alarm systems, security programs, and guns, yes, guns, soared. Many women found that if they chose to live in District of Columbia, they must become proficient in the use of a handgun. The same handguns which Senator Ted Kennedy and other bleeding hearts seek to deny to all Americans who are not criminals. As robbers and murders of cab drivers soared in the district, many cab drivers stopped picking up black fares and refused to deliver passengers to high crime areas. A group of yuppie black lawyers recently sued several cab companies because they had repeatedly been passed by when they tried to hail a cab. Mayor Barry had already forced a measure through City Council, automatically fining cab drivers $100 for refusing a passenger. See how they bait this thing here? See how they make it worse? More division. The Washington Post, in reporting on the yuppie lawyers' litigation, mentioned that 97% of the cab drivers in the District of Columbia were black. The black lawyers were suing their racial colleagues. You see that? The Post also interviewed taxi driver Albert K. Ashkapon, who said, "I discriminate a lot. I paid the $100 fine. I'm not going to put my life on the line." It is typical snobbery of black leaders such as Mayor Barry, who are surrounded by armed bodyguards and chauffeurs, that they wish to fine other blacks $100 because they are fearful of being murdered in what the press eventually refers to as a crime capital of the world. In Western cities, fake gunfights are staged for tourists in Washington. The gunfights taking place in Washington Capitol Hill are real. Nevertheless, Mayor Barry was recently quoted in the newspaper as remarking that the crime rate in the District of Columbia, if you don't count the killings, is lower than that in any other major American city. I can't believe he just said that. That's a quote, folks. Totally asinine statement. In the case of COM.PA versus Board of Directors of City Trust of Philadelphia, the Supreme Court ruled in 353 U.S. 230, 1957, that Stephen Girard, a patriot of the Revolutionary period who died in 1831, erred in leaving his large fortune for schools for poor white orphan boys. The funds which were used to found Girard College in 1848 could no longer be spent for the purpose which Girard had devised, according to the Supreme Court. Now, this is what you call him coming in and saying, "No, we're going to change things." Is that the right to be that way? Just think about it, folks. Despite a lengthy record of previous decisions which honored testamental directors, the court ruled that Girard's will, in the light of current sociological requirements, was now found to be discriminatory. His money could no longer be spent for the benefits of the poor white orphan boys. Is that not racism too, folks? If that's the way it is, if that's the way it was set out, then you have to do it that way. You see, everything is to bring harm. A farm is just also about, again, like I said, is to bring hate between white and black people. That's what it's about. A farmer was sued for raising grain in the SS of Department of Agriculture Regulation and feeding the surplus to his cows. What fucking business do you have to do with that? You see, a lower court ruled that some powers are granted by Congress by the Constitution, others are later conferred by amendments. Congress has originally no power to enact income tax or to prohibit the manufacture and sale of alcohol beverages, you see, but no amendment to the Constitution granted to Congress the power to regulate agriculture. No, never was. Supreme Court overturned this decision, ruling per curiam February 24th, 1949. The judgment is reversed. Wicker versus Filburn, 317 U.S. 111. The court handed down no written decision because its ruling for an order of reversal had violated both the 9th and 10th Amendments. Throughout its history, the qualification for nomination to the Supreme Court had remained the same: social, that is, solid political support. During the 19th century, nominees were frequently rejected by the Senate on partisan political grounds. In 1930, the Senate rejected an unusual distinguished nominee, that is Judge John J. Parker, because of his conservative views on race relations and labor law. A concerted propaganda drive by union political leaders persuaded the Senate to refuse him, and a preview of the famous Bork hearings of our era. Because of such political impasse as the shocking rejection of Judge Bork of the Supreme Court, Professor Lawrence Tribe suggested a compromise solution that the Supreme Court should maintain a constant political balance of 3 liberals and 3 moderates and 3 conservatives. When any justice left the court, he should be replaced by a successor chosen from the category in which he belonged. Tribe's suggestion was received with derision in Washington, because no one today can say for certain who is liberal and who is conservative, while moderates no longer exist. That's correct. There's no middle ground. Judge Bork had been rejected by the Senate as too conservative, although during most of his life he had been considered an extremist liberal. He had been married to a Jewish liberal, a socialist, and his closest friends for years had been the well-known left-wing Judge Abner Milkable, whose congressional career had been marked by his extreme pro-communist views. From the time of Brandeis, there had been a traditional Jewish seat on the Supreme Court, although no seat was ever reserved for anyone who might be considered even remotely anti-Jewish. When Frankfurter died, he was replaced by R.T. Goldberg. When Goldberg was asked to resign to defend Zionist interests in the United Nations as the ambassador for the United States, he was replaced by A. Fortas. At that time, no one could anticipate that Fortas would have to resign because of his connections with Las Vegas mob figures and with wheeler dealer Louis Wolfson, who later went to prison. Fortas has signed an agreement with Wolfson while on the Supreme Court that he would receive $25,000 a year from Wolfson Foundation for Life. The public outrage over this arrangement forced Fortas to resign. His form, Arnold, Fortas, and Porter had become the most powerful Washington lobbyists. While Fortas was serving on the Supreme Court, his wife took his place with the firm, bringing in many large new accounts. The firm has since dropped the Fortas name from its masthead. As part of the growing federalization of the legal system, the Supreme Court ruled that all state courts must now follow federal rules of evidence. You see what's going on here? The capitulation, whether they were in conflict with state statutes or not. See how they've gradually taken over state power. There's no defense, you see. This placed much greater restrictions on crime-fighting power of state and local police, as well as state courts. The justice had reversed traditional police procedures. Henceforth, no evidence could be presented in court if anyone in the police department had error in any way, no matter how trivial, in gathering the evidence, even if he meant that an obvious guilty and dangerous criminal, you see, would go free. A landmark reversal in the history of criminal justice in the United States, the notorious exclusivity rule was applied to the court of the Mallard decision of 1957. Mallard's 7.5 hours of detention before his arraignment was held by the Supreme Court to have violated his constitutional rights to be brought before a magistrate without undue delay. In 1961, the Supreme Court invaded another realm of state law by limiting the ability of local police agencies to conduct searches in quest of incriminating evidence, a domain previously held to be within the domain of state law. In 1963, the court Gideon decision released a convicted criminal, Gideon, on the grounds that every indigent such as Gideon should have a lawyer provided and paid for by the state. This decision, although doing nothing for the great majority of law-abiding Americans who still had to pay for their own legal representative, proved to be a great boom for the legal profession. Only one task yet remains for the Supreme Court: to outlaw any citizen representing himself in court or to appear without a lawyer, to continue the Supreme Court's chosen role as the Santa Claus of the legal profession. In 1964, the Supreme Court extended the exclusively right, that is the rule, by barring evidence seized during the search and seizure operation involving automobile. In 1964, the Escobedo decision freed a convicted murderer because he had not been allowed to see counsel at the station house before he made a full confession to the police. In 1966, the Supreme Court decided 4 cases comprising Miranda versus Arizona. The court ruled that the police could not question a suspect if he demurred, and the service of a lawyer must be interjectedly pressed on. Now, what was the motivation for that? Well, maybe it's to get a lawyer there, but also maybe it's to make some money. Not, him and financed by the state indignant. A federal ruling declared that the presence of a uniformed policeman in the station house psychologically acted to coerce the defendant and violate his Fifth Amendment rights. See the psychological part here, folks? The implication of the Supreme Court ruling was that whenever a criminal was being brought into the police station, those policemen present must either strip or absent themselves. Not only were these rulings ludicrous, they also reflect the dedication of social activist judges to the well-being of the criminal. It also reflected their active dislike and distrust of the police and for members of the law-abiding public. See, this is a war against the law-abiding public, folks. That's what it is. And it's within our own system. One might say that the Supreme Court no longer bothered to conceal its commitment to the criminal and its distaste for the bureaucracy property owners of society who have been catechized by Karl Marx and other communists in their writings. They ruled that the police must now be handcuffed, that is, while criminals were being given carte blanche to carry on their profession. Because of these decisions, as well as the increasing concern of the justice for communism, that is, public reaction quickly surfaced in national campaigns to impeach the most notorious liberal leaders of the court, Chief Justice Earl Warren and Justice William O. Douglas. Earl Warren had not always been known as a liberal. As a young Californian politician, he had a brilliant career until a family problem threatened his reputation. His father, according to researches by famed classical scholar, that is Dr. Revilo, that's spelled R-E-V-I-L-O, Oliver, had been sexually abusing a number of young women who were his tenants in a shanty town in California. Several rape charges had been filed against him, and Warren realized that he must act quickly. He went to talk to his father, who was then found with his head bashed in. Dr. Oliver states unequivocally that Warren murdered his own father in order to protect his political career. He was then elected Attorney General of California, but made no effort to find the murderer of his own father. The case was closed. As Attorney General of California, Earl Warren showed few liberal tendencies. He led the Committee of 100, a nativeless California group, in a campaign to have all Japanese small businesses and farmers interned after Pearl Harbor, despite the assurance of J. Edward Hoover and other intelligence officials that these merchants had been investigated and presented no threat. Warren and his cohorts insisted that Roosevelt intern the Japanese. Didn't know this, folks. This is wild. Their properties were then bought for a few cents on the dollar. Holy shit. By Warren and the members of his committee. Land which they attained for a few cents an acre in 1942 is now worth millions. The fortunes from the campaign not only financed Warren's later career, he also provided the financial backing for the successful presidential campaign of Richard Nixon and Ronald Reagan. Later elected governor of California, that is, Warren went to the Republican Convention of 1952 with a California delegation which had been pledged to the party nominee, that is Robert Taft, At the convention, Warren was promised the post of Chief Justice if he was switched to Eisenhower. It was an offer he could not refuse. When he arrived in Washington, Warren was told that the first case in the court docket was a very urgent one. It was Brown versus Board of Education, the school desegregation case. Hearing on this case had been begun on December 13, 1952. Chief Justice Fred Vinson soon let it be known that he was prepared to uphold the long-standing ruling of Pleasant versus Ferguson, which had long ago established the idea of separate but equal principle for American education. Few Washington insiders believed that the arguments in favor of Brown versus Board of Education would bring any surprises. It was but one of the series of cases which the National Association for Advancement of Colored People had routinely been bringing to the court. However, in this case, the NAACP had been given a special fund of many millions of dollars, donated by many New York Jewish families, such as the Springlers, who had run the NAACP for many years. These funds enabled the NAACP to hire many experts, more than 200 such witnesses, at a cost of more than $10,000 a day. Other funds donated to the NAACP came from such left-wing activities groups as the CIO Political Action Committee, the majority of whose dues-paying members were white, the Anti-Defamation League of the B'nai, the American Jewish Committee, and the American Jewish Congress, the American Civil Liberties Union, and yes, ally interests. And all the NAACP came to court to start over. And all the NAACP came to court for Brown versus Board of Education with a war chest of $10 million. In contrast, the southern states who argued against Brown had only a few $1,000s of expense funds to present their case. Now tell me what justice is all about, folks. It ain't about justice. It's about people who have money. Despite their massive expenditures, the NAACP, millions after some months of argument, had made little impression on the justices. The court had originally allotted 2 weeks for the hearing of Brown versus Board of Education. It dragged on during the 52 and 53 term of the court. It became obvious that the NAACP was desperately stalling for time. No one could then envision the denouncement for which the NAACP had been told to wait. A plan had been put into effect, which was to change the composition of the court and thereby to effect a favorable decision for Brown. The defending lawyer for the states was John W. Davis, a former presidential candidate, sent a note to his associate Robert Figg. I have never read a drearier lot of testimony than that furnished by the so-called educational and psychological experts. I think it is perfectly clear from interior evidence that the witness Clark drafted the appendix, which is signed by the worthy social scientists. I can only say that if that sort of gulf can move any court, God save the state. Davis was referring to the well-advertised psychologist Dr. Kenneth Clark, whose professor at Columbia University, Dr. Henry Garrett, was the most respected psychologist in America. Garrett stated that Clark had been none too bright as a student. Now the student was testifying before the Supreme Court as the originator of the doll test. He had shown both black and white dolls to a few black children, and he claimed that they had picked the white dolls in preference to the black ones. From these tests, Clark deduced that the Negro children were suffering from inferiority complex. Well, that's a really great test there, folks. We can all do that in kindergarten, can't we? Because they had picked the white dolls and that this complex had been created in them because they could not go to school with white children. No evidence was ever presented to the court which verified Clark's unsupported claims. He just pulled it out of a hat, just like a rabbit, you see. However, later court cases revealed that he had deliberately falsified his testimony before the court. He had conducted earlier tests in some northern states where the public schools had long been integrated. It was in those integrated states that the black children had picked the white dolls also. In the southern states which were not integrated, the black children had picked the black dolls. Nevertheless, Clark succeeded in placing his falsified findings before the Supreme Court. It goes on and on and on. This was not the most flagrant falsification presented to the court in Brown versus Board of Education. The presence of the principal advocate for the plan, the National Association for the Advancement of Colored People, never intimidated in any way that this association was not a National Association of Colored People. It had been founded in 1910 by a small group of white people. Present at this meeting were John Dewey, who was to revolutionize American education on socialist lines, Jane Addams, a lifelong socialist, Mary White Oblivion, only child of a millionaire Theodore Oblivion, from a well-known abolitionist family. He owned Oblivion's, the most fashionable store in New York's Fifth Avenue. Minnie White Oblivion's was the epitome of the wealthy white liberal, although she listed herself as a socialist in Who's Who. She resided for many years in a luxury suite in Brooklyn, that is at St. George Hotel. She spent her later years living on the fashionable Upper East Side of Manhattan. Also present at the founding of the NAACP were Rabbi Emmett Hirschberg, Rabbi Stephen Wise, Dr. Henry Moskowitz, and Lenin Walt and Florence Kelly, who had changed her name from Westky. Only one black was present at the founding of the NAACP. That is William E.B. Du Bois, a lifelong communist revolutionary who finally denounced the United States, gave us American citizenship, and went to live in Ghana, Africa. For many years, no black was allowed to head the NAACP. Mary White Oblivion was a chairman of the board after its founding. Albert Springleton, of a wealthy Jewish family, was present from 1911 to 1940. He was succeeded by his brother, Joey Springleton, a wealthy newspaper publisher who lived like royalty in a huge mansion. He also founded the publishing firm of Harcourt Brace. Harcourt Brace is a major publication for college books and in high school and college. Joe became treasurer of the NAACP. His brother, author, serving as president from 1940 until his death in 1971. The NAACP was the personal preserve of the Springleton family from its inception until 1971. Even while the NCAA was arguing Brown versus Board of Education before the Supreme Court, the justice never knew that no black person had ever served as president of the NAACP. Walter White, secretary of NAACP from 1931 to 1955, was scribe and current biography in 1942. It is only through his own insistence on his Negro blood, estimated by E.A. Hooton at about 164, that anyone would ever take him for a Negro. He has fair skin, he has blue eyes, and he has blonde hair. The official report of the Communist Party for National Convention stated that the party had penetrated the NAACP with Florence Kelly, or Wesniewski, a personal friend of Engels and Lenin, was on the board of directors, as was Felix Frankfurter. The field secretary, William Pickens, also a Socialist Party member, was active in communist affairs. The most interesting name among the founders of the NAACP in 1910 was that of Dr. Henry McCoskey. His wife, Bella McCoskey, was one of the most influential Democratic Party leaders in New York. She also had been a secret director of the Communist Party for years. That is, the Red Network. List a Dr. Moshewitz as Communist Party Central Committee. This is believed to be another spelling for the name of Dr. Henry Moskowitz. Bella Moskowitz ran Governor Al Smith's office for 8 years in alliance with Robert Moss and Judge Joseph Proskauer, the president of the American Jewish Community. Proskauer, Proskauer, personally selected all judges in New York State for years. Are you kidding me? Lewis Howe, Franklin D. Roosevelt press aide, were envious of Proskauer. He said to him one day, "By God, Joe, you've gone too far. This is not a single Gentile judge left in the state." Proskauer looked solemnly at him. "You know, Lou," he said, "I didn't expect to reach this goal for another 5 years." So Bella Moskowitz, born Bella Linder, and married a Charles Israelis. When he died, she married Dr. Henry Moskowitz. Again, that spelling is Moskobitz. Nathan Miller's biography of Roosevelt notes that on page 200, Moskowitz and prosecutors felt that Roosevelt, as a cripple, would be unable to interfere in their direction of the campaign. Like Al Smith, they viewed the patrician in politics with contempt, regarding Roosevelt as little more than a handsome piece of window dressing. When Roosevelt succeeded Al Smith as governor of New York, Smith said to him, "Now, Franklin, you will want Mr. Kalowitz, of course, and I think the best thing you can do is appoint her the governor's secretary." Bella Monacouskas, Bella, that is, was a longtime social worker, Communist Party worker, labor leader, Jewish leader, head of the Council of Jewish Women, and the communist who inducted atomic spy Julius Rosenberg into the Communist Party. It was she who put together the liberal coalition of Jews, communists, socialists, and labor leaders, which became Roosevelt's unbeatable political base. As head of the Progressive Party, she had nominated Oscar Strauss for governor. She was introduced to Al Smith through Abram Eccles, that is a law partner of Judge Proskauer, and became Smith's political alter ego. She became director of publicity for the Democratic National Committee and was given credit for the political careers of Newton Baker, Herbert Lehman, and Al Smith, but her greatest achievement was making possible the election of FDR to the presidency. She was denied her moment of glory when she fell down the stairs and was killed. A few days before Roosevelt's inauguration, 4,000 people came to her temple at Temple Emmanuel in New York. Al Smith described her as his alter ego. Neither then nor later did anyone ever challenge Felix Frankfurter, a sitting judge during all the arguments on Brown versus Board of Education before the Supreme Court, as to a possible conflict of interest because he had been a director of the NAACP for 18 years and was now hearing a case brought before the Supreme Court by the NAACP. How in the world can you not expect them not being biased in that situation? The ruling which the plaintiffs of Brown versus Board of Education sought to overturn was a well-established precedent, Plessy versus Ferguson, which laid down a guideline observed since 1894. Laws permitting or even requiring the racial separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other, and have been generally, if not universally, received as written within the competency of the state legislation on the exercise of their state power. Thus, the overturning of Plessy versus Ferguson requiring testimony and evidence which would justify the nullification of the state power to control its education in its schools. No such evidence was ever presented before the Supreme Court. Instead, a federal conspiracy between the plaintiff and the justice of the Supreme Court involving murder, resulting in a unanimous decision in favor of Brown. This conspiracy is documented in the authentic publication from the Harvard Law Review, 1987, pages 817, ET, sequel by Felix Frankfurter, longtime law clerk and confidant, Philip Eltman. In an interview by Brown versus Board of Eltman, Eltman stated, "There is no question that the grand strategy in all this inside the court was Felix Frankfurter. To use the Yiddish word that Frankfurter used at the time, he was the Kochleffer, I guess I'm going to spell it Kochleffel, or cooking spoon, which kept things stirred up. Frankfurter was in touch with the lawyers who won Brown, Jack Greenberg, Thurgood Marshall, William Coleman. It was a victory that changed the whole course of race relations in the United States. Eltman showed no remorse of the fact that this victory was won by means of conspiracy. Litigant contacts between the justice of the Supreme Court and the attorneys for the plaintiff, in which Eltman was the main go-between. The interviewer asked him about the obvious impropriety of this situation. Frankfurter was receiving a government briefing almost daily from you, to which Davis, that is the lawyer for the defense, never had a chance to reply. Eltman, that is, I regarded myself in the literal sense as an amicus curiae. Because of his complicity in illegal participation in the Brown decision, Frankfurter's latest books, essays, and articles mentioned neither the case nor his association with the NAACP. In an article on the Scottsboro Boys, as well as in the other civil rights articles, he made no mention of the fact that he was legal counsel for the NAACP. His many biographies usually omit such references, as does his Who's Who's listing, Justice Felix Frankfurter and Civil Liberties, by Clyde A. Jacobs, from the University of California, 1961, omits any mention of Frankfurter's position with the NAACP or of Brown, although one would suppose this would accrue central to the material from which the title was described. Phillips Kurland, Kurland's book, Felix Frankfurter, also neglects to mention the NAACP or Brown. Helen Shirley Thomas' book, Felix Frankfurter, confines the association to 5 words on page 21. Felix Frankfurter, legal advisor to the NAACP. Leva Baker's biography, Felix Frankfurter, page 310, notes that Frankfurter was a legal counsel for the NAACP. Baker also makes the startling admission that there was no doubt about where Felix Frankfurter stood. He had but one course to take on segregation. Thus, an impartial justice hearing a case on segregation left no doubt about where he stood. And what about the arguments before the court? How did they affect the decision? Eltman leaves us in no doubt about that. In his interview, he states that the judges had already made up their mind. Oral arguments made no difference in their decision. And Brown, noting that the lawyers said made a difference. Brown, nothing that the lawyers said made a difference. Thurgood Marshall could have stood up and recited Mary Had a Little Lamb, and the result would have been exactly the same. However, the principal evidence impeaching both Frankfurter and the court decision in favor of Brown in the record of Frankfurter's 18-year association with the NAACP, which both he and his biographers have tried to conceal. In the Brandeis-Frankfurter connection, that is the secret political activities of two justices, Oxford 1982, B.A. Murphy notes, page 201, in 1930, that is, Felix Frankfurter organized a crack legal staff for the NAACP to litigate against segregation throughout society. Although Frankfurter publicly resigned all of his numerous political affiliations when he was appointed to the Supreme Court by the FDR in 1939, including the NAACP, he continued to direct the legal staff of the NAACP from behind the scenes, as he had been doing for many years. During World War II, Frankfurter had one of his protégés, William D. Hastie, the dean of Harvard Law School in Washington, appointed by Secretary of War Henry Stimson, a key member of the Brotherhood of Death. Yes, that's the group. The Yale School, Skull and Bones. That's who it is. Henry Stimson, a key member of the Brotherhood of Death, as a special assistant on Negro problems in the armed forces. Furthermore, Frankfurter also had Stimson appointed as his two special assistants in the War Department. Two other Frankfurter protégés, Harvey Bundy and John J. McCloy. Murphy states that this was done to provide Frankfurter with an indispensable means for influencing War Department policy. Why would a Supreme Court justice need to influence War Department policy at the height of the Second World War? Because Frankfurter, a Vietnamese immigrant who had succeeded FDR's mentor, that is Bela Lugosi, as commander of the secret Harold Ware cell of Soviet agents in the government in Washington, needed to direct our war strategy in favor of its principal goal, the rescue of the Soviet Union from attack by the German armies. Murphy states that Frankfurter served as a constant intermediary between Stimson and FDR throughout the war. Throughout FDR's long regime, Frankfurter continuously placed his protege in key government positions, Secretary of the Interior. Ickes notes in his diary, March 24, 1933, that he appointed Margold, M-A-R-G-O-L-D, Assistant Secretary of the Interior after advising with Dr. Felix Frankfurter. This explains that Margold had been serving as a special counsel for the NAACP. It was necessary for Frankfurter to avoid any mention of his 18 years association with the NAACP during the court hearings of Brown, because he had personally organized, selected, and trained the lawyers who were arguing the case. He had inaugurated the NAACP campaign of litigation against segregation. Each of the lawyers appearing before him was his personal protégés, and another protégé, Eltman, was secretly serving in an animus curiae for Brown. This document evidence proves that Brown was illegal, decided though improper contact with attorneys, conspiracy to obstruct justice, and is invalid, as there is no statute of limitations on conspiracy. The court decision in Brown versus Board of Education now stands invalid, returning the situation to the rule of Plessy versus Ferguson, maintaining the separate but equal schools. Every racial integrated school in the United States, whether public or private, is now operating illegally. Eltman's Harvard Law Review interview also recounts the exact wording of Frankfurter when Eltman met him at Union Station after the news of Vincent's heart attack. Eltman said that Frankfurter stated happily and sarcastically, "I'm in mourning," meaning he was making fun. "Phil, this is the first solid piece of evidence I've ever had there really is a God." Eltman also revealed that Frankfurter had code names for each of his fellow justices, which demonstrated his ultimate contempt and hatred for them. His private name for Justice Stanley Reed was Chamber, the Yiddish word for fool. Eltman also expressed distaste for Kenneth Clark's testimony in Brown about his doll test. He trivialized the basic truth and opened himself and the NAACP. He trivialized the basic truth and opened himself and the NAACP to ridicule. John Davis was a lawyer for South Carolina, and he demolished the doll test. He cited an article by Clark, Racial Identity and Preference in Negro Culture, in 1947, in which Clark stated that they had given his test not only to black kids in southern states, but also black kids in northern states. And the strange result was that the southern kids were significantly less likely to reject the white doll than the northern kids. Eltman also attributed Warren's use of the phrase "with all deliberate speed" to integrate the schools in the Brown decision to Frankfurter. He stated that it was originally quoted by Holmes from Francis Thompson's poem, The Hound of Heaven, and that Frankfurter liked it so much that he quoted it in 3 of his decisions. Thus, we have the Supreme Court decision which changed the educational system throughout the United States, arrived at by the murder of one Chief Justice and his replacement by Earl Warren, who placed himself totally in Frankfurter's hand. We had an amicus curiae from Brown, who was a Frankfurter law clerk, advising a staff of lawyers arguing for Brown, who had been handpicked and trained by Frankfurter at the NAACP to litigate against segregation. No other case ever heard by the Supreme Court so reveals a conspiracy, illegal activities, improper contamination of the Supreme Court justice, and absolute nullification of the subsequent decision by these document factors. The Academy argues for Brown and NAACP was provided by voluminous scholar work, The American Dilemma by a Swedish socialist, Gunnar Myrdal, M-Y-R-D-A-L. Both Myrdal and his wife, Ava, were longtime Rockefeller Fellows. She served as a member of the Swedish Parliament, was a director of UNESCO, a member of many United Nations organizations. She and her husband had toured the United States in 1929 and 1930 as Rockefeller Fellows, where they developed a deep-rooted contempt for Native American workers. Gunnar Myrdal spent from 1938 to 1942 working on An American Dilemma. He was funded by the Carnegie Foundation, which was run by the Rockefeller interests as a subsidiary of the Rockefeller Foundation. The book, 1,483 pages, was published in 1944 by Harper Brothers, New York. Carnegie had been headed for many years by Frederick Capel, a director of Equity Life and Guarantee Trust, the bank which had sought throughout the 1920s to increase American funding and recognition of the Soviet regime, which we talked about that already, which was not from that book, but was from this book. You've been lied to about everything, folks, especially here with us in America. I don't know what it's like in other countries, but this stinks the high of it. Carnegie had also funded Lord Haley, an African survey, and had given millions of dollars to Tuskegee and Hampton institutions. Myrdal had also spent a year in the United States as a fellow of the Laura Spelman Rockefeller Fund. McKelpert on the staff of Carnegie at this time were Ralph Bunche, B-U-N-C-H-E, named as the Communist Party member, M.F. Ashley Montague, and a tireless communist propagandist, Eugene Horkowitz, Herbert Goldhammer, Melville Hershkovitz, and Edward Shields, and Benjamin Malzberg. An American Dilemma, which was never read by any of the justices, reeled of Myrdal's contempt for native-born Southern white citizens. On page 563, we read, the low level of education and general culture in the white South is another important background factor. Another important background factor in the causation of lynching, and other major forms of violence is the isolation, the dullness of everyday life, and the general boredom of rural and small-town life in the South. Myrdal then asserts the people as narrow-minded, intolerant, evangelistic. He writes with disapproval of their evangelistic religion. On page 565, Myrdal writes approvingly of the growing strength of Southern liberalism. On page 582, he writes, there is a great class of Southern whites who are also poor, uneducated, coarse, and dirty. One can envision the fictitious Myrdal recoiling in horror from the dirty white Southerners as elitists and beneficial of the Rockefeller billions. It must have been an ordeal for him to travel for 4 years in the South for his research on the American Negro problem. The problem is not the Negro at all, the coarse and dirty white Southerners, that is on page 597. He writes of the lower class of whites in the South, but he never uses such terminology in writing of the Negroes. He also follows the Communist Party line by including several pages of vehement denunciation of police statistics of Negro crimes. One wonders what Merigo would make of the front page of the Washington Post, which daily recounts the staggering incidents of Negro crime, which has made our nation's capital the crime capital of the world. Had the justice of the attorneys for the Southern school system ever bothered to glance at the 1,483 pages of American Dilemma, they would have been shocked at its rabid bias against the South and its white citizens. Yet this book was cited as a principal influence on the final decision of the Supreme Court in favor of the plaintiff in Brown versus Board of Education. This evidence, which was never argued before the court, actually impeached its own goal. Why would black children be improved by being forced to attend schools with coarse and dirty Southern whites? Perhaps it was a subtle ploy to aid Southern whites by giving them the opportunity to associate with emancipated, well-spoken, and highly intelligent, motivated black children. The 1952-53 session of the Supreme Court closed with no decision announced on Board versus Brown of Education. It was then scheduled to be carried over to the next section. However, the anticipated outcome was never in doubt. Justice Reed and others in the known stated that they expected Chief Justice Vincent to uphold Plessy versus Ferguson, ruling against any radical integration of the schools. John W. Davis, lawyer for the defending Southern states, announced that there would be a 6-3 decision against Brown versus Board of Education. The ruling was expected shortly after the opening of the fall term. On the June 5, 1953, the 5 segregation cases before the court were redocketed for October 12, 1953, re-argument. Washington observers expected a short hearing and that Vincent would then issue the 6-3 ruling against Brown. This had already been established by internal memorandums of the court. This opinion was never issued at 3:15 a.m. on September 8, 1953. Chief Justice Vincent died suddenly of a heart attack in his suite at the exclusive Warman Park Hotel. Only 63 years old and enjoying robust health, Vincent has shown no signs of any health problems. It was but one more of those strange government heart attacks, you see, which had played such an important role in major policy decisions. Despite their shock at his sudden death, Washington insiders saw no reason to change their expectations that the NAACP would still lose the segregation case perhaps by 5-4 ruling instead of the 6-3. Nevertheless, a few of the protagonists greeted the news of Vincent's death as a day of liberation. Justice Frankfurter, on being informed of his longtime colleague's death, courted gleefully, "This is the first indication I've never had that there really is a God." He was referring to the Canaanite god, that is, Baal, the agent of Lucifer, who apparently had been summoned to dispose of Chief Justice Vincent. Years passed before Frankfurter himself was revealed as the secret head of the influential Harold Ware communist cell in Washington. As the death of Bella Malakowski, Frankfurter had inherited her leadership of the communist agents in the Roosevelt administration. At the same time that Frankfurter was serving on the Supreme Court, his brother Otto Frankfurter was serving a long sentence at the Anamosa State Prison in Iowa. On October 5, 1953, President Eisenhower announced that he had named Earl Warren to replace Justice Pinson as Chief Justice. It was immediately noted that Warren, a newcomer to Washington, had placed himself in Frankfurter's hands. There was still no indication that the new appointment would change the expected ruling on Brown. Arguments in the case were decisively resumed, but months went by with the case still in limbo. Washington journalists still expected a brief announcement that a decision be made against Brown. On May 17, 1954, at 12:52 p.m., with no prior notice, Chief Justice Warren began reading the court decisions in Brown versus Board of Education. His first stated that all the evidence presented by the NAACP had been inconclusive, which seemed to verify the fact that Brown had lost. However, Warren then stated, as a unanimous decision of the court, we conclude that in the field of public education, the doctrine of separate but equal has no place. Therefore, we hold that the plaintiffs and other similar situated for whom the actions had been brought are by reasons of the segregation complaint deprived of the equal protection of the law guaranteed by the 14th Amendment. In view of our decision that the Constitution prohibited the states from maintaining racial segregated schools, it would be unthinkable that the same Constitution would impose a lesser duty on the federal government. Warren's statements that the Constitution prohibits racial segregated schools went beyond the scope of the arguments of the NAACP. It had nothing to do with that, folks. The Constitution actually said nothing on the matter. The decision unleashed chaos throughout public education in the United States. The amazing ruling, even more amazing because it was unanimous. Instead of the long anticipated 6-3 ruling against Brown, was based on no legal accepted evidence. Clark's doll manipulation and Monroe's vicious denunciation of white Southerners were evidence which would have been laughed out of most courts. Rumors immediately began to circulate that Vision had been disposed of in order to end his opposition to a ruling in favor of Brown. His son, Fred Vinson, a classmate of the present writer at Washington Lee University, also died suddenly while at the Department of Justice. Kenneth Clark evidence, later revealed to have been distorted, still threatened the validity of the Supreme Court ruling. NAACP lawyer Jack Greenberg then took a desegregation case for the Fifth Circuit Court of Appeals for a prearranged decision as follows. We reiterate that no inferior federal court may refrain from acting as required by the Supreme Court in 1954, the Brown decision, even if such a court should conclude that the Supreme Court erred as to the facts or to the law. This amazing ruling tried to dictate that Brown could never be overturned, even if it were proved to be in error, as was the case. However, in the last case, Evers versus Jackson, Mississippi, Municipal School District 232, F Supplement, that is 241, 1964, Federal Judge Sidney Mize noted, in this case, the evidence as to racial difference as such significance as to reasonably require the separation of school children for education purposes is overwhelming, undisputed, and unchallenged. In the opinion of this court, the facts in this case point up to a most serious situation and indeed cry out for reappraisal and complete review of the findings and conclusions of the U.S. Supreme Court in the 1954 Brown decision. Washington insiders now conclude that Chief Justice Vinson had indeed been murdered as part of the sinister plot to force racial integration schools on all Americans by the use of armed troops. Earl Warren became governor of California through one murder and Chief Justice of the United States through another. Justice Felix Frankfurter was never criticized for the fact that he had been a director of the NAACP at the time he ruled in their favor, nor did he reveal that he had personally selected the attorneys for the NAACP. Jack Greenberg, a longtime associate, and Thurgood Marshall. Marshall was then named to the Supreme Court himself, where he failed to disqualify himself in a long possession of racial sensitive case before the court. Loyal to the end, he always voted for his employer, that his employer is the NAACP. In 1987, the Harvard Law Review reported a stunning fact about the Supreme Court milestone ruling in Brown versus Board of Education, which declared racially segregated public schools to be unconstitutional. Justice Felix Frankfurter had secret, improper, and unethical contacts with a lawyer for the plaintiff, with a view to engineering a victory for that side. He seceded. Detroit Free Press in March 29, 1987. The editorial commented that had it been known, Frankfurter would have been impeached, removed from the bench, and ruined. In fact, Frankfurter associates of many years with Jack Greenberg and Thurgood Marshall in the NAACP is proof that a legal conspiracy was effective and that Brown versus Board of Education thereby totally invalidated. All persons who claim injury as a result of the forcible integration of the schools can now bring action against the government as any school district which has been adversely affected by the ruling. It now seems evident that a further goal of the Brown versus Board of Education decision was to destroy the rapidly growing and independent black middle class throughout the United States. A black elite composed primarily of ministers and educators that succeeded in raising the standards of blacks in many areas, threatening the traditional plantation system by which communist revolutionists such as Frankfurter and wealthy white liberals as Mary White of Oblivion used black citizens for their own ulterior purposes. Thus, blacks have much reason to sue the government for damages resulting from Brown versus Board of Education as whites, if not more so. The present black residential neighborhoods are now drug tormented, crime-ridden areas in which no one is safe, neither stable family nor an effective education system is possible. The Brown ruling was recalled in the Washington Post, April 22, 1989, in an interview with Charles Lofton. Lofton had been principal of the black elite high school, Dunbar High School, which produced many black leaders in the Washington area. He commented that I have more influence in my students in the segregation environment. They used us as a role models. I was at Dunbar when integration came in, and it knocked us out. We had been getting the cream of the crop, but with integration, students had to go to schools in their zones. I lost some of my finest teachers because there was just not the same demand for subjects such as Latin or advanced calculus. Partly as a result of integration, our children do not have as positive a sense of self. We have lost a whole generation, a generation from 16 to 32, and we're never going to get it back. The calculated destruction of the Black elite had made possible the total government control of the Black population, that is. The dedicated Black teachers and ministers have been pushed aside, replaced as role models by drug pushers and political demagogues. One Black educator warned that we now realize that a terrible crime has been committed. An entire generation of Black youth has been deliberately tossed onto the scrape heap by false leadership, which has left the Black community disorganized and without hope. Black leaders are also concerned about an apparent campaign to eliminate the entire Black population in Africa through the deliberate inculcation of AIDS and by famine and starvation. The dark continent can then be returned to Rothschilds and to the tender administrations of Global 2000 as a largely uninhabited area rich in natural resources, which can be plundered at leisure. That's another key ingredient there, folks. When you're no longer on the land, you'll be able to plunder the natural resources. Interesting. After Brown, Chief Justice Earl Warren found that his most consistent supporter on the liberal court was Justice William O. Douglas. In the later desegregation case, Douglas delivered the amazing opinion that no one has the right to attend a segregated public school. Due to his continuous pursuit of young women, Douglas soon began to exhibit serious signs of mental and physical degeneration. He became increasingly paranoid, claiming that listening devices had been planted in his office. He sometimes asked lawyers to step out into the hall to carry on conversations. He endured more criticism when he married again. In the well-advertised case of the child bride, a New York Times story of August 21st, 1988, cited J. Edward Hoover opinion of Justice Douglas as revealed in FBI files. Of course, Douglas is crazy and is not in too good of health. During years of senile degeneration, he continued to occupy a seat on the Supreme Court. His writings were a continual puzzle to clerks and other officials of the court. In The Brethren, that is, we are told, page 243, former clerks were called regularly for clues to the meaning of Douglas' notes and his frequently incomplete reference to old cases. His sentences were almost a private code, their meanings evidence only to him. This book goes to discuss Douglas' continuing incompetence, which caused his family to ask him to resign. He indignantly replied, "No, there will be no one on the court who cares for blacks, Chicanos, defendants, and environmentalists." Despite their increasing aggravation at Douglas' presence, protocol prevented the other judges from filing complaints about him. He had long since lost control of his lower body functions, and continuous noxious odors rising from his chair, sometimes causing his fellow justices to become physically ill. At the time the segregation decision was announced, blacks occupied all the low-level services and maintenance jobs at the Supreme Court. There was not a single black secretary in the entire building. Court personnel were routinely ordered to do personal work on their own time for the justice, such as taking Oriental rugs to the cleaners, shopping, and going across the city or other errands. The court was exempt from civil service laws, you see, and employees could be fired immediately with no appeal. Numerous work hazards existed throughout the building. The black service personnel worked on rickety scaffolds, sometimes resulting in serious illnesses. The great bronze doors were regularly cleaned and polished with hydrochloric acid, which had long been outlawed in American industry. After Douglas' death, Justice Thurlow Marshall represented the most liberal bias of the court. A protege of Zionist Justice Brandeis, he had been a member of the ACLU for many years, studied the Apocoria, New York version of the Lenin School, the New School for Social Research, and served as a special counsel for the NAACP from 1937, when he was personally approved by Felix Frankfurter, until 1961. He delivered a stinging denunciation of the Constitution in a recent speech. Rumor is rife in Washington that he suffers from Alzheimer's. An article by Department of Justice Attorney Terry Eastland of the National Review, April 21st, 1989, while justice sleeps. Notice that Marshall sleeps through oral arguments and spends much of his time in the court building, watching television situations, comedies. A favorite is I Love Lucy. He let clerks write his opinions and told Life magazine, I don't know what that word is, I guess, and petitions, I ain't giving no break to no drug dealer. Disgusting. Although the Supreme Court renders 130 opinions each year, Marshall's the only assigned 15. He refuses to retire and vainly hopes that the Democrats would win in 1988 so that another liberal could be appointed in his stead. In The Brethren, that is the book, Marshall is described as being overweight, drinking too much, eating too much, and thoroughly soured on his work. He has had one heart attack from which he never fully recovered, but still refuses to retire until a Democratic president has been elected. The history of the Supreme Court reveals a steady retreat from his assigned roles in protecting the legal rights of all Americans. In 1833, the court ruled that the Bill of Rights provided only protection against federal authority, but not against state action. In Barron versus Baltimore, the city was sued because it had impaired the value of the plaintiff's property. Barron claimed that this was taking his property without due compensation, and thereby violated the Fifth Amendment. Chief Justice Marshall ruled that the Bill of Rights only secured against apprehended encroachment of the general government, not against those of the local governments. Marshall's ruling has never been reversed, although it was superseded by 3 Civil War amendments of 13, 14, and 15. On restricted covenants, that is, the court dismissed the Corrigan versus Buckley in 1926, effectively upholding restrictions covenant, that is. 22 years later, the court effectively nullified restrictions covenants by forbidding the state to enforce them. Chief Justice Vinson ruled in Shelby versus Kramer and McGee versus Seps, S-E-P-E-S, in 1948, with 3 justices abstaining. We hold that in granting judicial enforcement of the restrictions agreement in those cases, the states have denied petitions to equal protection of the law, and that therefore the actions of the state courts cannot stand. In 1989, the courts hesitated somewhat in its heretofore upholding of affirmative action cases by stating that a person cannot be deprived of his legal rights in a proceeding to which he is not a party. This seemed to end the era of class actions in which ruling affecting large groups of Americans had been routinely handed down, even though most of them had never been a party to the action. In 1945, the court vainly attempted to stem the rapidly growing monopolization, I should say, of the media by ruling that the First Amendment presupposes that the widest possible dissemination of information from diverse and antagonistic sources is essential to the welfare of the public. This decision was later used as the basis for the 1978 court decision, which prevented daily newspaper owners from buying radio and television stations in the same cities as the newspapers, and thereby establishing a media monopoly, I should say. Decisions seem to have had little effect in preventing media moguls from expanding their empires. It was recently predicted that within the next decade, 4 giant corporations would control all of world communications. The Supreme Court ruled in Totten, T-O-T-T-E-N, versus U.S., 92 U.S., that public policy forbids the maintenance of any suit in a court of justice, the trial of which would inevitably lead to the disclosure of matters which the law itself regards as confidential, or respecting which it will not allow the confidence to be violated. This will seem to guarantee personal privacy, but it has not restrained judges from routinely ordering all personal papers and records to be turned over to the opposing party in general lawsuits. The considerable Masonic direction of the Supreme Court throughout its history was documented in 1988 by Paul A. Fisher's book, Behind the Lodge Door, a veteran of the OSS and the Counterintelligence Corps. Fisher used his considerable talents for intelligent analysis to build an irrefutable case for the domination of the courts by the Masons. It began with Chief Justice Marshall, who was a Grand Master of the Virginia Lodges, and documented the fact that the secret oath of the Masons have played a major role in court decisions ever since. Let me take a drink of water here. He notes that FDR's plan to pack the court originally with 4 Masons, whom FDR subsequently appointed to court, that is, Black, Burns, Milton, and Jackson. Another recent study shows that 9 of the 16 members of the Congressional Committee on the Judicial are Masons, showing that the continual Masonic influence still permeates not only the Supreme Court, but the entire judicial. This influence extends not only to the justice, but to their law clerks as well. In the book called The Brethren, we are told that the law clerks in the office of the Chief Justice has exercised great power. The way things work in the Chief's chambers gave them tremendous influence. Warren told them how he wanted the cases to come out. So much for impartiality. Woodward and Bernstein also quoted Warren's successor, Chief Justice Burger, on Warren as sloppy, politically motivated, and interested more in results than legal reasoning, a man without intelligent honesty. Despite the fact that the RICO law, the Racketeer Influence and Corrupt Organizations law enacted by Congress, has been perverted by the Department of Justice from its stated purposes of fighting organized crime to a weapon of terrorism against legal legitimate businesses. The Supreme Court recently refused to recognize this perversion. More than 1,000 RICO suits are being filed each year. 93% of them have no connection with organized crime. The Wall Street Journal and other publications have repeatedly denounced this rape of justice. Nevertheless, on June 26, 1989, the Supreme Court refused to rein in the law. The court ruled 9-0 to continue civil suits for triple damages, although Justice Scalia admitted that the law is so vague it violates the Constitution. The court now faces a challenge in its necessity of ruling whether the judicial can impose direct taxes. U.S. District Judge Russell Clark has ordered Kansas City property taxes increased by 95% to pay the cost for forced desegregation, and ignored the will of the voters by authorizing the school district to issue $150 million of capital improvement bonds. The 8th U.S. Circuit Court of Appeals upheld the judge's arbitrary actions, which clearly flouts the Constitution and which totally abrogates Article 1, Section 8 by giving the courts power to tax. Holy shit. The Supreme Court is expected to issue a decision in the case by October 1989. Justice Clark's action is typical of the social activism in which the Supreme Court itself has taken the lead. A Washington Post story stated December 28, 1988, declared many in Washington view as a judicial activism running wild. 7 judges forcing this wealthy township, that is Bedminster, New Jersey, to build housing for the less fortunate, nearly tripling its population. Senator Gerald Carney said of the judges, they think, like all social planners, that their view of society is superior to everyone else. The court is destroying the democratic process. For years, the New Jersey Supreme Court has been headed by Chief Justice Robert Vincelance, heir to the political power wielded by his father, a Democratic wart healer, and Bernard Barach activist. David Vincelance has prosecuted Bruno Hoffman in the Lindbergh kidnap cases, as exposed by Anthony Scalia in his groundbreaking book, Scapegoat. Vincelance had never before tried a criminal case of any kind. He had been appointed Attorney General by Governor Harry Moore as a political payoff for switching the support of Baraj Masonic power to Moore's campaign. Vincelance, determined to convict Hoffman, despite the lack of evidence, he rounded up a group of witnesses who were willing to commit perjury. Most of their incredible testimony with crudely manufactured evidence. Vincelance's principal witness was an 87-year-old Amadeus Hoffmuth, who testified that Hoffman had driven up to him on the day of the kidnapping and inquired the way to the Lindbergh's residence. Social Security records proved that Hoffman was not only legally blind from cataracts, but was also hopelessly senile. Vincelance also withheld from the jury the Reliance Property Management Paybook, which proved that at the time of the kidnapping, Hoffman was working in New York. When J. Edgar Hoover was informed of Vincelance's activities, he indignantly ordered all FBI agents to withdraw from the case. He refused to have the Bureau's work contaminated by such crude perjury. Hoover also expected the roof to fall in on Vincelance when his conspiracy was exposed. Hoover remarked to his associate Clyde Colson, I don't know if Hoffman will ever go to jail, but I'm damn sure Vincelance will. In fact, with the Bernard Baruch power behind him, Vincelance succeeded in having Hoffman convicted and electrocuted. For years, his widow, Anna Hoffman, worked to have the frame-up exposed, but she was jeered at by the entrenched powers of the media and the legal system. With this typified the unbridled arrogance of the judicial who daily wields their power in our courts. The Associate Press noted in December 29, 1988, that a Fort Lauderdale judge, J. Leonard Fleet, routinely sentences lawyers who displease him or who are late comers to the court, or even if their mode of dress offends him. He orders them to go to the supermarket and buy food for the poor. Again, this is social activism, has nothing to do with the administration of justice. However, it is typical of the rate of justice, you see. The Portland, Maine Press Herald recently decried the practice of retired federal judges drawing full pay, even though they no longer hear any cases. It cites former Chief Justice Warren Burger, who receives $115,000 a year. The editorial note that 20% of all senior judges draw full pay, even though they do no work. However, in view of the omnipresent acts of judicial tyranny, it might be better if we retired all of them, you see. The Yonkers case, which was headlined daily in the press throughout 1988, typified the judicial dictatorship which now terrifies our people. Federal Judge Leonard Sand personally decided that the city of Yonkers, the fourth largest city in New York, was not doing enough to wipe out racial discrimination. He ordered the city to build 1,000 new units for blacks in residential neighborhoods in which substantial racial integration had taken place. After residents opposed the order, he imposed $500 a day fines on 3 Yonkers City councilmen and a fine on $1 million a day against the city itself. The judge resided in Chapel, a wealthy white suburb north of Yonkers. Columnist Pat Buchanan wrote, "What is happening in Yonkers is outrage. A Harvard-educated dictator in black robes, elected by no one, is ordering the fourth largest city in New York against the will of his people and elected officials to spend millions of tax dollars building public housing it doesn't want or need, an area Sand alone would determine. If Yonkers refuses, the judge will destroy the city financially and jail its elected officials. Will someone explain to me what exactly George III did to our forefathers compared to that? British troops who tried to enforce the decree as a dictatorial as Judge Sands would have been met with armed rebellion. The hidden explanation of Judge Sands' actions, the present writer explained in The World Order, is that every public official has a secret agenda to aggravate and increase racial tensions by every means possible in order to provoke a raging conflict and provide the excuse for active government repression against all groups. That's what it's about. The minorities continue to be helpless pawns in the obvious but never openly stated program. The Supreme Court again maddened the populace with its July 4th approval of the desecration of the flag. One Joey Johnson, a New Yorker who echoed the staunchest tenets of the Leninists, claimed that the flag is a symbol of oppression, international murder, and plunder of a sick and dying empire. He was then arrested in Texas for publicly burning the flag. Supreme Court in Texas versus Johnson ruled 5-4 that burning the flag was a free speech exercise which was protected by the First Amendment as a political statement. The front page of the Washington Post headline, "Court Nullifies Flag Desecration Law." Just below it was another feature story, Soviet-U.S. becomes partners. The majority of the judges ruled that conviction for flag burning was not consistent with the First Amendment. Judge Stevens dissented. The value of the flag as a symbol cannot be measured. The court is therefore quite wrong. Chief Justice Rehnquist noted, the flag has come to be the visible symbol embodying our nation. Millions of Americans regard it with almost mystical reverence regarding what sort of social, political, or philosophical belief that may have. Pat Buchanan wrote another stinging column about the flag burning decision on July 6, 1989. He stated for 30 years a despotic court had been writing into our Constitution and law its own arrogant ideology, its own prejudices, its own view of how a rational society should govern itself, casting aside as so much trash the deepest sentiments, traditions, beliefs of the American people, all the accumulated wisdom of the race. The predominant Christian people had yoked upon it as an alien, secularist concept of the good society. America today is two countries with values in conflict, where they celebrate raunchous dissent, we tolerate it, where they believe the marketplace of ideas must remain open to all sentiments, no matter how pernicious, seditious, or disgusting. We believe there are limits to the toxicity of the moral pollution a democratic republic can stand. We've had enough of judge-made law. So that's my conclusion tonight in chapter 5. As I've read from this particular book, The Rape of Justice, And it's interesting what we call this was a chapter with chapter 5 dealing with the Supreme Court. And it's amazing how much Eustace Mullins did for research here. I mean, it's just amazing. And yes, how courts have been now a way of buying also. So this is my conclusion tonight. Chapter 6 will be next time I get a chance to read it. Be the court as an arena. It's an arena, not a court anymore. So I appreciate you all being here. And thank you for listening, even though it's approximately 2 hours long. It's just valuable information you need to know. Again, I would encourage you to look into these particular books by Eustace Mullins and Dr. John Coleman. And, I'm going to be doing, like I said, I shared earlier, that I'd like to do the book on Neil Postman's book, Technocracy, which would be a good book. I find that Neil Postman was way ahead of his time, brilliant writer. And hopefully we'll be able to do some videos on him here in the near future as I read from that particular book. But anyway, thank you for being here, and I wish you a good night, and you take care.